Attorney Kaltsas is also the host of the Senior Focus, a program which airs Mondays on WCRN 8:30 a.m. and Wednesdays on Chatter TV 3, which addresses topics pertinent to the senior population. Nick's mission, both personally and professionally, has been to be a champion of the rights of the elderly and disabled. He is also the organizer of this event today. Please help me in welcoming Nick Kaltsas.
Yeah, I'm waiting for appointment to a board by President Barack Obama. But we're not going to talk about politics today. The one thing I do want to say is that, when you take a look at this issue from a medical perspective, from a clinical perspective, it's a lot easier to digest the information. Joanne spoke from a compassion, emotional perspective. I'm a little bit at a loss for words because I thought that the presentation that she gave was so impactful. It really is a disease that affects people in a rather dramatic way. And because of the work that I do as an elder law attorney, I see people that suffer from a cognitive decline very frequently. And whether someone comes in and maybe they had the diagnosis of Alzheimer's disease, but they aren't impacted by it at all. They don't have a cognitive decline. They're still able to make financial decisions. They still have the requisite legal capacity to enter into legal documents, or maybe meet with the person and for maybe 5 or 10 minutes, you don't notice anything, they seem fine. But after you're with them for 15, 20 minutes, a half an hour, you realize the person is affected greatly by it. Or perhaps you meet with someone who knows that they were brought into your office and knows that that person that was sitting on the other side of the table brought them in, but they don't realize that person is their spouse or one of their children. So, I suppose the threshold question is, does the person with Alzheimer's disease have the legal capacity that's necessary to execute legal documents, whether it's a power of attorney, whether it's a healthcare proxy, and those are probably two of the most important documents that can be executed by someone who is laboring with this disease, and depending on other financial considerations and other situations that they have. Perhaps a revocable trust or irrevocable trust. There's a number of different things that they should think about. And, the important thing, like Joanne said, when you've got the diagnosis, don't wait. The moment you leave your physician's office, you should really seek some kind of legal counsel. And I'm not saying it so that someone comes to me. I don't care where they go. The important thing is that if you procrastinate, you end up losing the requisite legal capacity to enter into documents that you really need to enter into so that there's a smooth transition down the road. And as soon as that diagnosis is made, it is really to your best interest to go and seek legal advice as to how you can plan your future so that, as things deteriorate down the road, you're able to have as smooth a transition as possible. Now, with respect to competence and capacity, in Massachusetts, Chapter 231, Section 85K, basically says that all people that reside in Commonwealth that are 18 years of age are deemed to have full capacity to enter into these legal documents. And in the event a person is to be deemed not competent, to not have legal capacity, the only one that can do that is a judge. So you have to go to court and seek to have the person adjudicated incompetent. And there are a number of different types of capacity. Legal capacity, the capacity to contract, testamentary capacity, and we will talk about each of these separately. The first one that I want to talk about is legal capacity. And, you know, you hear people talk about legal capacity, and you might think, you know, what is legal capacity? Someone who can understand the consequences of their action. They appreciate whatever document they've entered into, what it's going to do, who it is that's going to do whatever the document allows them to do. With respect to the capacity to contract, a lot of people are probably thinking, yeah, well, if someone has Alzheimer's disease, enters into a contract, what is the likelihood that that contract will be enforced? You know, I suppose it's a good question. I can tell you that whenever you end up in court, it's a crapshoot. You're not really quite certain which way it's going to go. The idea is to avoid court if you can. However, if you do end up in court, then the issue of whether an individual has the capacity to contract or not is going to be looked at in three basic areas or categories that will establish the capacity. And first is going to be whether the individual is a minor. As the statute said, once you're 18 years of age, the law is going to deem that you have full capacity to execute legal documents. So when we say minor, we talk about someone who hasn't attained the age of 18. Or intoxication, the person intoxicated when they entered into the agreement. And again, of course, the third one would be insanity. But as I indicated, if a person is to be deemed to lack the requisite capacity to enter into a legal document, the only one who can do that is a judge. So, in the event you were to go to court and bring the requisite proceedings to have the person adjudicated as incompetent, then it's going to be much easier to establish a category where the court's going to feel comfortable to nullify the person's commitment under contract. If the first time you bring that issue to light is in court, then it's going to be rather difficult to institute. Now, with testamentary capacity, and you know, I could say that regretfully, I've seen this, you know, more and more frequently. Whether it's someone bringing in someone who's suffering from a cognitive decline, a cognitive inability to enter into documents, and they say, hey, look, you know, my mom, my dad, my spouse, they need to enter into a will or a trust. And you look at the person, you talk to the person, they don't have any idea who their kids are. They have no idea what kind of money they have, and they lack the requisite capacity to enter into that kind of document. So, as far as testamentary capacity, the person really needs to understand and appreciate the document, what the document is going to do for them. Have an idea of what their estate is comprised of. Do they have CDs? Do they have stocks? How much money on a monthly basis income do they have coming in? A lot of people might not know specifics, but they have a general idea. I don't think that a person needs to know with specificity the precise dollar amount of each particular account they have, or how much money they have coming in, but at least have some general idea. A lot of people that I see have absolutely no idea, and I think it would be unfair, not only to family members, but to the person, him or herself, for them to enter into some kind of testamentary document for the disposition of those assets, when that person doesn't really have any idea what kind of assets they have. And the last requirement, to be aware of the person's natural objects of the bounty, just means know who your loved ones are, know who your family is, know who your friends are. A lot of people that will come in will be at a stage where they don't know any of that, yet they're brought in by someone who seeks to have that person establish some kind of a testamentary plan, and you know, that's not something that's fair. With respect to testamentary capacity, there are a number of different factors that can impact a person's ability to accurately indicate what it is they want to have happen. in the event of their demise. And as the slide says, the first one would be physical illness or emotional illness or undue influence. With respect to physical illness, I think we're looking at factors that would center around, as the slide says, brain dysfunction. Maybe certain medications that they take that don't allow them to think clearly. Maybe a person has a physical disability to the point where the only way they can indicate approval or disapproval to a question you might pose to a document is a nod of the head or a grunt. That's okay. If that person has a cognitive ability to understand the consequences of that document, the consequences of the actions of that document, should they enter into it, that's sufficient. However, if a person isn't able to understand, then that physical illness prevents them from entering into a testamentary document. With respect to emotional illness, the mere fact someone has mental illness in and of itself doesn't mean that person is incapable of creating some kind of testamentary document. Whether it's a will, whether it's a trust, whether they want to go to the bank and put other names on the accounts as well as their own. So the mere fact of the diagnosis of mental illness does not in and of itself mean that the person can't attend to their affairs. So there really is, as the slide says, no one-size-fits-all answer. You have to take a look at the particulars of that person's life and what the factors are that impact their ability to make these testamentary decisions. A person can have Alzheimer's disease, and they can fade in and out of lucidity. And in a moment of lucidity, when they have testamentary capacity, they know who the bounty of their estate is, who their loved ones are, who their children are, their friends, what kind of assets they have. They're able to enter into a testamentary document. You don't have to have that lucidity on a continuous basis all the time. It's probably not an easy thing. And in the event there is a context to the document, of course it's going to be more difficult to establish that the person was lucid when they entered into the document. If you enter into that document further into the progression of the illness, I think Dr. Summers indicated that there were a number of different stages, that there were 7. The early in the progression of the illness, you seek to plan for the future, make it so that any progression of the illness can be easily taken care of in the future. It needs to be done as soon as possible. In the event a person delays that until the later stages of the illness, they may be forcing a loved one, rather than being able to execute legal documents, force a loved one to go into probate away. And as maybe some of you have heard me say before, I'm not a particularly huge fan of probate. You end up going into probate court, and you try to get the court to do what it is that you want done, and like I say, it's a crapshoot. Sometimes it can happen, sometimes it's not going to happen. In the event, you're at the early stages of your illness, of Alzheimer's disease, and you have a particular scheme that you'd like to see with respect to the disposition of your assets, it's much more effective if you enter into an agreement, a document, whether it's a probate, testamentary document, a will, a probate document, or a non-probate document, so that your assets pass by operation of law, a trust, so that you say with specificity how you want your assets distributed, rather than having your assets passed by the probate court and laws of common law. undue influence. You know, when people come in and they'll bring in someone who's suffering from some kind of cognitive decline, you know, oftentimes they'll attempt to get the person to execute a document a particular way, whether they're looking to have the assets distributed solely themselves to the exclusion of other family members, or disproportionately to themselves to the exclusion of other family members. And they exhibit that they try to unduly influence the person. Well, a will is going to be held valid unless an interested party challenges it. There needs to be an objection to the will. File the will as a petition, probate the will. In the event someone feels aggrieved that what happened wasn't right, they can object, they can challenge the validity of the will. In the event the probate court finds that the will was executed as a result of undue influence, they can nullify the will. So the will won't be void ab initio. It's not void from the moment it was executed, but the court can nullify the will. Of course, when the court nullifies the will, then the disposition of the assets are going to go by intestate succession. There is no will, so whatever laws that are written for the Commonwealth with respect to the distribution of your assets to your heirs, in the event you don't have a will, is what's going to control. Now, to prove that undue influence, there are a number of factors that you have to establish satisfaction for. First is that the testator, the person who executed that document, is susceptible to influence. Second would be that that testator was deceived and unduly influenced by a third party, and that the person who executed that testamentary document succumbed to that undue influence. As don't process, if a person has a diagnosis of Alzheimer's disease, the longer they wait to attend to their financial affairs, the more difficult it becomes. It's important enough that I'll say it again. Advanced planning is what needs to occur so that there's a more smooth transition as a person's cognitive ability deteriorates. It's a progressive illness. Things that aren't going to get better. A lot of people are in denial and they think, oh, you know what, this will pass. It'll get better. But it doesn't. It just gets worse and worse and worse. At an early stage, when you still have the ability to make decisions for yourself, that's when you need to execute these documents. And the legal documents that I'm talking about would be surrogate decision-making documents, testamentary documents, Medicaid planning documents. I think testamentary documents, Medicaid planning documents can pretty much be grouped together. When I'm talking about Medicaid, I'm also thinking about Medicaid application, mass health application. Long-term care facilities, a person might be looking at 10, 11, 12, $13,000 a month. A lot of people don't have that kind of a monthly income, and they need assistance to help them pay for the cost of long-term care. We all know that long-term care is very expensive. There are things that you can do to make eligibility for those benefits something that's available to you, but there must be advanced planning first, because a lot of people will come in at the very last moment and will look to do some kind of planning, and you have to explain to them, well, there's a 5-year look back. So before an application goes in for benefits, there needs to be a gap of 5 years to cover whatever transfers, whatever conveyances you make. So the earlier a person were to plan, the better. Now, we're talking about surrogate decision documents. When I think of a surrogate decision-making document, I think of a power of attorney, and I think of a healthcare proxy. Now, the durable power of attorney is a contractual document, as the screen says, is guided by the laws of agency. There's a principal, you appoint an agent to act on your behalf in the event you're not able to do so for yourself. There are different types of powers of attorney. There are limited powers of attorney, there are immediate powers of attorney, there are springing powers of attorney. So there are a number of different documents that you may be interested in, and I don't have time to go through all of them at the moment, but when a person has the diagnosis of Alzheimer's disease, and you know that it's a progressive illness and things aren't going to get better, they're only going to become more complicated, more difficult down the road, as early in that process as possible, you should seek competent legal advice and find out what a person might be able to do to protect themselves and their families. The longer in the process a person waits, far more difficult it becomes. Now, it says it's primarily used for financial decisions. In Massachusetts, there's also a healthcare proxy. You see, the power of attorney is used predominantly for financial decisions. So, CDs, a bank business, stocks and bonds. You need to deal with an insurance company, the Internal Revenue Service. To make financial decisions, they're going to want to see a power of attorney. Maybe not at the very beginning, but when push comes to shove, the person is truly not able to communicate to themselves. If you're asked, well, what legal authority do you have for me to be able to rely upon your direction, it would be extraordinarily helpful for you to be able to take a power of attorney and fax it to the prosecutor. If you're not able to do so, too many times people have come into the office and told me, well, I'm trying to help my mom or I'm trying to help my dad, but they're asking for a power of attorney and I don't have one, so can you do one for me now? And then you meet with their mom and their dad and you realize they don't have the capacity to do so at this point. They're forced to have to go into probate court. You look at a surrogate decision-making document, whether it's a power of attorney, whether it's a healthcare proxy, you might be looking at a couple $100. You have to go into probate court, you're probably looking at many thousands of dollars. So by delaying, not only do you increase your level of frustration and the time delay and anxiety, but it's far more costly as well. So the earlier you attend to these things, the better. A healthcare proxy. A lot like a power of attorney, it's a contractual document as well. It's also guided by the laws of agency. There's a principal, and the principal appoints a healthcare agent and healthcare alternate. And they use it for healthcare decisions. So if you take a healthcare proxy, and I've been asked this question, if you take a healthcare proxy to the bank, they're probably going to look at you like you have two heads, because it doesn't authorize you to make financial decisions on behalf of the person. But if you have a validly executed healthcare proxy, and you put it in the hands of your medical provider, whether it's your physician or your hospital, they're going to take direction from your agent. And in the event they refuse to take the direction of your agent, you have an obligation to transfer the care to a medical provider, another physician, who will adopt whatever direction you're providing. Testamentary documents, last will and testament, the will is the document that takes it to probate court. You have to go to probate court. Directs the distribution of your assets. You get to tell the judge who it is you want to get what. There needs to be filing of citations, notices, petitions, accounts, inventories. It's a timely process. It takes about a year. A lot of people don't want to force their loved ones to have to go into probate court, so they'll execute other testamentary documents. A revocable trust or an irrevocable trust. revocable trust can be used for a number of different reasons, but at this point, I'll say that it's used basically if a person does not want to part with control over their assets, and it's kind of like taking money from one pocket, putting it into the other pocket. It's still your money, you still control it, you do whatever you want with it. If you don't want that trust anymore, you can get rid of it. You can destroy the trust. You can change and revise and amend the trust. If it's an irrevocable trust, it's like taking money from your pants pocket, putting it into someone else's pants pocket. And I'm going to zoom right along because I see Donna looking at me. So what I do want to say is that for a Medicaid plan, for Mass Health, you have to have an irrevocable trust, one that you can't change. At least you cannot change the dispositive provisions, the provisions relative to the distribution of your assets. A lot of people will come in and will think, oh, I'm all set for Mass Health. I have a trust. You'll look at their trust as a revocable trust. It doesn't help them at all. So, in conclusion, these packets are available in the back of the room. And in the event someone is so inclined that, you know what, yeah, I'm motivated, I am going to go. And you know what, it is time to do a power of attorney. It is time to do a healthcare proxy and certain testamentary documents, whether it's a will, whether it's a trust, whether it's revocable, irrevocable. You can put all of your documents into the packet. We give them away. There's no cost to it. And I can't tell you how many times someone's come into my office and said, well, I know that my mom and my dad appointed me the agent, power of attorney, but I don't know where it is. I don't know what to do. Well, if they're not able to put their hands on the documents that they need to be able to provide help to you, even though you might have done it when the person was cognitively able to do so, if they no longer have the capacity to do so, that person has to go into probate court and get an appointment from the probate court. And again, it's something that I think if you can avoid it, you probably want to avoid it at all costs if you can. So in any event, I'm going to end my presentation at this point. Thank you all for coming. Want to take some questions or no?
These kits are available at the end of the day, not right now, okay? So nobody has to rush to get down there. On your way out at the end, the last table, Elder and Disability Law Advocates table, has the Be Organized kits free of charge to anybody who wants one.
Any questions?
I'll be right back with that answer.
Someone's coming to get the microphone to you right now.
What is springing power?
I'm sorry?
What is springing power?
A springing power is a document that creates a contingency before the document is valid. So you might say something like, this document is only valid upon my incapacity, and my incapacity is to be established by a letter from my physician, my primary care physician, and the specialist. In the field of cause of my disability, you might have a paragraph that has that kind of language right in the document and have an area for the physician to sign. So it's something that doesn't take effect immediately, but at some particular point down the road.
What is the difference between the statement trustee for versus in trust for having to do with finances?
I don't think there's any difference. Trustee for or in trust for. I mean, I suppose you can look at the particular document that, has that language. One indicates that the person's the trustee for what the beneficiaries are of the document, and the other thing means the same thing as well.
Thank you.
You're welcome.
For a durable power of attorney, do you have to go to a lawyer? And then when do you need an irrevocable trust?
I don't think that you have to go to a lawyer. I think you can find documents on the website. You can probably go to Staples. You can probably find documents on the website. But the problem that I see is that in the event someone is in, the phrase that I use, penny wise and pound foolish, right? They don't want to spend money to go to a lawyer and get it done. I'm not saying come to me. I'm saying go anywhere. I don't care. If you spend, I don't know what the programs cost at Staples. I bet you they're like $150, $200 anyways. And you execute that document, you sign it, but there are errors in what you've done. They don't do what it is that you need done, and then something happens. The person that wants to rely on that particular document finds that the document itself is flawed in some way. There can be rather tremendous financial consequences. So maybe a person saves $100 or $150 or whatever the case might be by not going and having the document professionally prepared. But then, maybe down the road, they find out that the document is flawed and they incur, potentially hundreds of thousands of dollars of expense. So, I think the person needs to weigh the pros and the cons of which way they want to go. With respect to the difference between the revocable and the irrevocable trust, I suppose, the best way for me to address, that particular question would be some people don't want to part with control and they're not comfortable putting assets in an irrevocable trust that they don't control. If it's a mass health question, if the person has a mass health issue, then if they don't want to part with control, so they put it in a revocable trust, so long as they realize that affords them no protection whatsoever. And all of the money in that trust, except for $2,000, is going to have to be spent down. If it's placed in an irrevocable trust, they'll get protection immediately. But there's a 5-year look-back period. Benefits won't begin flowing to you unless you put in your application after 5 years has gone by and you transfer or conveyance of the asset into that trust. Does that answer your question? Thank you.